Hi everybody. On 30th of January 2026, the HRERA Gurugram bench passed an order in a single sector 103 affordable housing complaint, 24 pages, one allottee, a refund of 21 lakhs 14,506 rupees. Routine on the surface, right? But that one order has now built a legal corridor that walks past your SPV, walks past your project escrow, and lands directly on your personal balance sheet. If you are a Gurgaon developer with even one registered project today, this is the single most important order of 2026 for you, and almost no one in the industry has actually read it. So the question here is, how on earth did 121 lakh refund complaint open the door to personal asset attachment for an entire class of Haryana developers? What exactly is the legal mechanism that turns a project delay into a charge on promoter's own house in DLF Phase 1? And most importantly, what are the legal lessons that every developer, every director, and every HNI buyer in this market needs to learn from this order before the AFS filing deadline of 30th September 2026? Let's start from the basics, because before you can understand why Banerjee matters, you have to understand the architecture of how project money is supposed to move. This is what we call the 70-30-100 liability cascade. And let me tell you very candidly, this is the single most misunderstood concept in real estate finance. Here is what actually happens. Let's say there is a developer in Sector 99 Gurgaon. Let's call him Rakesh. He has 100 flats, 50 lakh rupee each. Total project receivables is 50 crores. So under section 421D of the RERA Act, read with HRERA Gurugram bank account direction, notified in Gazette on 10th of May 2019, Rakesh maintains 3 accounts. Direction 33A, the project master account, 100% of every rupee from every buyer lands here first. Direction 33B, the RERA compliant separate account, 70% auto transfers daily, locked, construction and land cost only, withdrawal certified by an engineer and architect and a chartered account in place. Direction 33C, the promoter's free project account, 50% sits here for margin and overheads. So far, this is what Rakesh's CFO told him. 2 buckets, clean architecture, SPV shielded. But now, read the third proviso of section 421D and the affidavit Rakesh signed when he registered the project. It says in writing that if the project expenditure already incurred exceeds the receivables, the promoter shall deposit the balance from his own resources before any further withdrawal. You realize what this one line does? It converts the 70-30 split the moment the project hits deficit into 100% exposure on Rakesh's personal balance sheet. The 30% of his free account gone first, then his other accounts, and then his other assets. The escrow architecture was never a wall. It was a valve. That valve is what HRERA opened on 30th of January 2026. Now apply that framework to Mahira Home Sector 103 Affordable Group Housing Society. 26 September 2019, Priyanka Banerjee signs the BBA. Total consideration 24,16,790 rupees. She pays 21 lakhs 14,546. Tri-party agreement with PNB Housing Finance dated 7th of August 2019 and due date of possession is 29th of July 2024. Then comes the unraveling. 18th May 2022, HRERA's site visit team arrives. Physical construction stands at 15 to 20%. The money withdrawn from the project bank account suggests it should be much higher. On the very next day, the authority freezes every project bank account under Section 35. 11th March 2024, registration of the project is revoked. And finally, on 30th of January, HRERA delivers the Banerjee order. And this is where, ladies and gentlemen, the door opens. Because the Banerjee ratio does 3 things in one paragraph. Door number 1, once Section 7(1) revocation has been triggered, the promoter, in the words of the authority, cannot carry out the business. That amounts to discontinuation of business within Section 18(1)(b), and the moment Section 18(1)(b) is triggered, every paying allottee in the revoked project gets refund of every rupee paid with Rule 15 interest from the date of each payment till realization. Not just Priyanka Banerjee, every allottee. Behind door number 2 is Section 40 of the RERA Act. Section 40 subsection 1, recovery as arrears of land revenue executed by the district collector. Or Section 40 subsection read with Rule 27 of the Haryana Rules 2017 executed by the principal court as decree, that is, when attachment, sale, garnishee and arrest in execution wake up, your Sushant Lok flat, your Mehrauli farmhouse, your bank accounts, all on the table. And door number 3, the capital infusion affidavit. The third proviso to section 421D read with the 2019 directions, already signed, already binding, already on the file. So the question over here is, how does this stack up in actual rupee value? Run the math on the Banerjee figures. Principal paid 21,14,546. Interest rate at 10.80 as per Rule 15 as on the date of the order. Period from each payment date to realization. Roughly 6.5 years of interest accruing on principal she could not access. For Banerjee herself, the total exposure runs well into the high 30s of lakhs. And the formula in para 16 is allottee blind. Every paying allottee in Mahira Homes 103, same math, same rate, same corridor. That is your aggregate exposure on a single revoked registration. Now let's compare it against another case, Renu Mathur and another versus Countrywide Promoters and BPDP Limited. HRERA Panchkula, 16th December 2024. Project Park 81, allotment date 20th of July 2011. BBA 7th July 2011. Deemed possession 7th July 2014. Occupancy certificate 20th of July 2022. 8 years late. The authority's calculation 11.10% interest from 7th of July 2014 to the date of the order. Accrued interest payable 39,60,181 plus 33,799 rupees every single month thereafter till physical possession on one flat in one project against one developer. And in the same order, the authority struck down cost escalation charges of 1,52,524 rupees, struck down club charges of 50,000 rupees, held that GST was not chargeable on payments before 1st of July 2017, held that chargeable area was the OC area of 1,251 square feet, not the developer's super area calculation of 1,536 square feet. Do you realize what is happening? Every line item the developer has been adding to the buyer's statement of account, the authority is now testing against statute, line by line, and almost every developer line item is failing the test. But this looks one-sided, right? Surely the developer has defenses. Well, guess what, guys? Every developer's CFO, every developer's lawyer has 3 standard defenses when this hits the table. And in the last 15 months, all 3 have died. Defense number 1, force majeure, the COVID excuse, the NGT ban, the EPCA closure. Renu Mathur kills this in 2 lines. Any event post-dating the deemed possession date cannot by definition have caused the breach. Renu Mathur's deemed date was 7th July 2014. The NGT was 2016. The pandemic was 2020. None of them touched the 2014 breach. The authority quoted Halliburton, Delhi High Court, May 2020, verbatim. COVID is not a get out of for a deadline that was already missed before COVID arrived. Defense number 2, the settlement waiver. The full and final document the developer extracts at the moment of possession. On 21st January 2026, the Allahabad High Court at Lucknow delivered Sushma Shukla, and I quote, "No private contract or settlement can have overriding effect on the rights and obligations created by statutory provision of the law. Statutory interest under Rule 15 is welfare statute interest. It cannot be waived by contract." And in Renu Mathur, the HRERA said, where the project is jointly allotted, a settlement signed by one of the 2 allottees binds nobody. Half-signed settlements are not settlements. Defense number 3, the IBC moratorium. The classic CFO play. Push the company into CIRP, freeze every recovery proceedings under Section 14 and wait it out. On 1st of April 2025, the Supreme Court delivered Rakesh Bhanot. The IBC moratorium protects the corporate debtor. It does not protect the directors or the signatories from check bounce prosecution. In October 2025, the Bombay High Court at Nagpur applied that rule in the real estate promoter context in Ortho Relief Hospital. 3 defenses, 3 doors slammed in 15 months. So long story short, this is how by stacking section 7(1) revocation on top of section 18(1)(b) refund on top of the third proviso of section 421(d) on top of section 42 civil court execution on top of Rakesh Bhanot personal director liability, RERA has without a single new amendment to the parent act built a corridor from a sector 103 affordable housing complaint all the way to the promoter's personal Mehrauli farmhouse. The corporate veil isn't just pierced, it is bypassed. And cherry on top of the cake, if the developer wants to appeal, section 43 subsection 5 of the RERA Act bars the appellate tribunal from even hearing the appeal until promoter pre-deposits 100% of the refund and interest payable, which the tribunal cannot waive. So even fighting back is structurally expensive. And for developers outside Haryana, let me be very clear about this. Maharera, UP RERA and Karnataka RERA have near identical escrow directions. The cascade is national. Banerjee is just the first order to walk the full corridor. And this brings me to the most important part, the legal lessons that every developer, director and HNI buyer needs to draw from these orders. Lesson number 1. While ordinary developers treat the AFS 1 to AFS 8 annual filings under Regulation 5E of 2020 compliance regulations as accounting paperwork, sophisticated developers treat them as live litigation documents. The 10,000 rupee per day late fee is the cheapest line item in the matrix. The expensive line item is the Regulation 9 forensic audit, which then triggers Section 7(1) revocation, which then triggers Section 18(1)(b) refund liability across the entire allottee pool. The chain runs from a missed AFS filing on September 30th to a charge on your personal house. That is the full cascade. Lesson number 2. No matter how cleanly your JDA is drafted, if the landowner's name appear on the RERA registration, in the BBA or the project advertisement, the Bombay High Court has settled the position that landowner is a co-promoter under the explanation of section 2ZK. And here, get the language very precisely. The statute says jointly liable. It does not say jointly and severally. Rajasthan RERA order dated 30th of June 2020 is the clarificatory authority. Argue jointly and severally in court and you will be corrected from the bench in seconds. And last and most importantly, every section 7(1) revocation order is either an ending or an opening, depending on which side of the table you are sitting on. For the original promoters, it is the start of personal asset cascade. Your accounts are frozen, your registration is gone, your allottee pool has a statutory refund path, your appeal costs 100% pre-deposit, your check signatories face criminal prosecution even though CIR pay. But for a distressed asset acquirer with a clean balance sheet, watching the same HRERA revocation list every Monday morning, this is the cleanest entry point into a Gurgaon land bank that the current law offers. Think about what you are acquiring. Land already titled, approvals already obtained, allottee pool already identified, the stalled promoter's entire negotiation leverage gone. Because the regulator has done the demolition work for you, you are not acquiring a distressed project. You are acquiring a cleared site with a captive buyer base at recovery price with the full force of the authority's order behind you. The same order that destroys Rakesh in Sector 99 lets a smarter operator pick up the project at a fraction of its original cost in a market that has gone cold on luxury resale and NRI demand. That is the single biggest opportunity arbitrage left in the NCR real estate. This is an analysis of a public order and statutory provisions. It is not a personal legal advice. But if you have even one registered project in Haryana, the next AFS cycle for financial year 25-26 closes on 30th September 26. And Banerjee is now a precedent. We have built a one-page document called the HRERA Personal Asset Risk Checklist with a side-by-side comparison table of pre-Banerjee and post-Banerjee enforcement. It covers the third proviso capital infusion test, the section 7(1) revocation indicator, the Vadhva Group co-promoter check, the Rakesh Bhanot check protocol, the section 43(5) pre-deposit budget and the AFS filing audit trail. Link is in the description, bill to be forwarded to your CFO, your CS and your project council before the next board meeting. That's all from my side today, guys. If you learned something valuable, please hit the like button, and for more deep dives into Indian law for promoters, directors and decision makers, please subscribe to the channel. Thank you so much for watching. I will see you in the next one. Bye bye.